Hi everyone, thank you so much for joining us today. This is another beautiful Friday, and we will be talking about intellectual property and for innovators. So I'll be handing over to the moderator for today, Grace Idoko. Thanks for joining us, Grace. Over to you.
Okay, thank you so much, Ma. Good evening, everyone. Thank you so much for joining today. My name is Grace, and I'll be your anchor for this evening. Okay, just give me a minute. So I hope all the groups are ready. So I'll just go ahead to introduce the program we're on to today. So the JIIPCC Intellectual Property Mentorship and Internship Program is a quarterly program for students, young professionals, and IP enthusiasts across Africa. Mentees are afforded the opportunity to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. So this program seeks to encourage continuous training, development, and evolution in Africa, and around the world. So you can watch our videos by searching for JIIPCC on YouTube and Facebook. So as you all are aware, this is a very great program. Personally, I have benefited a lot from this program. I was once a mentee myself, and I can attest to the fact that this program has helped me so much in my IP journey and beyond. So I just want to encourage all of us to, especially the mentees, to take this program seriously. It can go a long way in your career. So that being said, so I will just go ahead to, we have a few announcements here. We're streaming live, so please, all the mentees, if you can, kindly put on your video so that we can see you, so that when we see somewhere else, we can recognize you. And then please kindly change the name of your phone to your name so that we can take attendance and know those that attended and all of that. Thank you very much. So I'll just go ahead to introduce our mentors. I don't know if they have joined us. Let me just check. Okay. Most of the mentors are not yet here. Can I go ahead to read their profile in their absence?
Yes, you can.
Okay. So we have two mentors for today. Our first mentor is Mr. Folarin Aluko. He is a legal practitioner. Sorry, give me a second. In the firm of Turum Rockwood Solicitors, where he provides advisory and consultancy services to companies and a wide range of creators, users, and startups. He is also a director of the IP Institute in Nigeria. He is the chairman, board of trustees of the Intellectual Property Lawyers Association in Nigeria. Mr. Folarin is a member of the board of trustees of Sports Lawyers Association in Nigeria, as well as a member of the board of the Nigerian Digital Chamber of Commerce. Mr. Aluko is also a board member of the Songwriters Association of Nigeria with a background in ICT, hardware, and digital forensics. Mr. Folarin has led legal teams to champion consequential strategic impact public interest litigation in the IP space since 2012. Mr. Folarin is a consulting mediator with commercial intermediates, an ADR firm based in Lagos and Abuja. He is a thought leader in Nigeria's innovation, technology, intellectual property, and entertainment space. So we're so lucky to have you, sir. And thank you so much for being one of our mentors. I've personally been in one section that he was a mentor and I learned a lot. Our second mentor this evening is Mr. Max Ekong. Mr. Max Ekong is the founder and principal of Everlaw Associates. He works extensively in the field of arbitration, ICT technology law, and intellectual property. Mr. Max is the facilitator on the annual program, Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business since 2010. So we're so lucky to have them both on today's episode. We're very lucky to have them. So we'll just go straight on to the group presentations. I don't know if the groups are ready.
So we can hear from group one. If group one is ready, you can just unmute yourself and share your screen. Thank you.
Okay, if group one is not ready, any group that is ready can start so that we don't waste so much time. If group two, if the representative of group two is ready, please you can unmute yourself and start. Thank you very much. Or group three or group four.
Good day, everyone.
Good evening, yes.
Sorry, can everyone hear me?
Sorry?
Can everyone hear me?
Yes, we can hear you.
So I'm Salami Oluwatos and I'll be presenting on behalf of group one.
Good, go ahead. Thank you very much.
I'm coming. I'm trying to share the screen.
Okay, so you have 8 minutes to do your presentation. So kindly bear that in mind as you present.
All right.
All right. So I wait.
Okay, so our topic for today is IP protection for innovators in engineering. Introduction. Briefly, what is intellectual property? Intellectual property is a set of laws that protects creative and innovative products through legal rights called patents, copyrights, and trademarks. It is sometimes described as property that is a product of the mind or a product of intellectual capital. Intellectual property protection is critical for protecting a company's proprietary designs, processes, and innovations. The 4 types of intellectual property protection are patents, trademarks, copyrights, and trade secrets. Patents protect an invention or a technical product or process. Engineers are often on the front line of innovation. As consultants, they also share intimate details of their clients' designs, materials, products, and processes, which are highly confidential. Engineers then are professional innovators who work in the realm of industrial property and are often the first involved in creating a proprietary design or invention. The next subtopic is engineering IP protection. The electrical and mechanical engineering industries produce the components and products which facilitate our modern lifestyle. Engineering is a dynamic sector with valuable research and innovation and breakthrough technology. Proprietary designs, processes, and products are significant in the engineering sector. Companies in the engineering industry, such as mechanical engineering or electrical engineering companies, must clearly define their intellectual property and protect their designs, processes, and inventions. Intellectual property protects the competitive advantage of the company, its market share, and its reputation. As the world is characterized by increases in manufacturing capacities globally and particularly in China. It requires companies to have more research and development and more innovation. Intellectual property rights protect the work and innovation of engineers and companies. Patent application. Every schematic, each piece of code, software code, and every drawing, diagram, and prototype has intellectual property rights attached upon creation. States the Institute of Electrical and Electronic Engineers in a publication, Intellectual Property and the Employee Engineer. These rights are the legal essence of an engineer's output, or if an actual disk or prototype is lost, the other can always be added. But if the legal rights are lost, the disk or prototype may be worthless, even if securely in hand. Although these are multiple aspects to IP protection, all engineers must be very familiar with patent law. Russell J. Jennett, a partner with Nixon Peabody LLP in Chicago, indicates the top two IP issues affecting engineers are failing to seek patent protection for new innovations and publicly disclosing new inventions before filing a patent application, resulting in a waiver of their patent rights. IP protection. Companies such as Bosch, Hitachi, and Mitsubishi Electric invest in research and innovation to maintain their competitive advantage. They develop and manufacture products, design systems, and tailor solutions for complex projects. Companies are aware of the need for IP protection and the high cost of not doing it. Dedicated departments and consultants work to create IP assets, register patents, make sure patents are competitive, and enable the company to take full advantage of its intellectual property. Other measures including preventing the entry of counterfeit products into a territory. For example, Mitsubishi Electric distributes its products only through a network of authorized distributors. The program helps to provide authentic, safe, and reliable products and reduces the risk of customers buying counterfeit products, and also reduces the issue of gray market products. Gray marketing or parallel importation affects multiple industries globally, including the electrical and mechanical sectors. With gray marketing, your branded products can be sold by unauthorized distributors who compete with your authorized dealers and usually sell your product for a lower price. But it can also be authorized distributors who participate in the gray market in breach of agreement. Gray marketing is ever more prevalent due to the global reach of online sales. It reduces overall sales and can damage brand reputation. The damage of counterfeits. Counterfeiting is increasing across industries for big corporations as well as medium-sized organizations. Europe's mechanical and plant engineering sector lost an estimated 7.6 billion euros, which is over $7 billion, to product piracy and counterfeiting in 2019. According to industry body VDMA, as reported by security industry. The report also shows that in the German mechanical and plant engineering sector, over 90% of companies with over 500 employees are affected by piracy. Counterfeiting involves imitating product components, and design. Product components are required mainly for machinery and are important parts of the engineering industry. As designs become more advanced and complex, there is a lot to gain from imitation. Design IP can help create differentiated processes and products protected as a system, module, or equipment, even when there is no innovation. Without protection, counterfeiting will continue to damage sales and reputation, while often creating a safety risk. Safety issues can affect operators or users of machinery and may affect the ability to operate the system. Intellectual property issues. The most significant issue is the need to register a patent for new innovations. Innovations can be the development or improvement of a product or method. When innovation exists, it is crucial to obtain a patent, maintain, and defend it. Another issue is being careful not to publicly disclose new inventions before filing a patent application. Engineers and organizations may reveal their innovation in an article or a presentation. However, public disclosure can result in a waiver of patent protection, even if known through your own action. In the case of Coco versus A.N. Clark Engineers Limited, the plaintiff designed the moved engine and sought the cooperation of the defendant in its manufacture. After the plaintiff disclosed to the defendant all the details of his design and proposals for its manufacture, the parties fell out and the defendant decided to manufacture their own engine. The plaintiff alleged that the defendant had deliberately broken the contract with him with the view of using his design without compensation. And when the defendants brought out their own design, which closely resembled the plaintiffs, it brought a motion for an interlocutory injunction to restrain the defendants from misusing information communicated to them in confidence solely for the purposes of the joint venture. Defendants denied that any confidential information had been supplied to them or used by them in their engine. The court outlined 3 elements essential to a cause of action for breach of confidence, which are A, that the information was a confidential nature, B, that it was communicated in circumstances importing an obligation of confidence, and C, that there was an unauthorized use of the information. Now, the impact of this information is when claiming a remedy under intellectual property, it is important to be able to clearly identify the information and explain how it is being misused. The plaintiff in this case failed to do so and thus set out his claim for an injunction. Also, in the case of EPI Environmental Technologies and another versus Symphony Plastic Technologies PLC and another, the claimant had developed an additive which would assist in making plastic bags biodegradable. They allege that in breach of confidentiality agreement, defendants had copied the product. The defendant said the confidentiality agreement was ineffective. It was urged that the part of the information copied was not confidential, having been previously disclosed. Conclusion: competition is fierce, but while honest competition helps to drive innovation and growth, illegal imitation and production is harmful. Therefore, intellectual property protection is crucial for companies in the highly specialized fields of engineering. To prevent IP infringement, both offline and online companies must manage their IP. A clear understanding of the IP situation is essential for IP protection strategy. It is crucial for IP rights registration and protection. It is also significant for existing IP in order to better use, reuse, and defend it. Thank you.
Thank you very much, Oluwatosin. Thank you so much for that wonderful presentation. Okay, so
Welcome.
okay, thank you. The representative of Group 2, are you ready to present?
Yes, good afternoon.
Good afternoon. Go ahead. Please, you have 8 minutes. Thank you.
No problem.
Jesus.
Please, can you see my screen now?
Sorry? No, we can't see your screen yet.
Okay. I'm trying to.
Any member of your group can, okay, we are seeing your screen now.
Okay. Can you still see it now? Okay.
Yes,
Good
I
afternoon.
can.
I'm Esther Loyo. I'm presenting on behalf of Group 2, and our topic is intellectual property protection for innovators in the communication industry. First and foremost, I would like to defend themselves in the topic. Intellectual property is intellectual property refers to the creation of the mind. Types of intellectual property include patents, trademarks, copyright, trade secrets, industrial designs, etc. Communication industry is the business of conveying information that encompasses a broad field of activities consisting of a lot of subfields and sectors that produces various kinds of content, services, and products of communication. These industries include many fields of activities ranging from call centers to technopoles, from computer factories to software and data mining firms, from press activities to internet applications, and also refers to production of cultural goods and journalism. Communication industry is a diverse and competitive and an interconnected industry that uses terrestrial, satellite, and wireless transmission systems. From the definition, it's obvious that communication industry is a very broad industry, and in the interest of time, I would only be focusing on the internet. According to Wikipedia, the internet is a global system of interconnected computer networks that uses the Internet Protocol suite to communicate between networks and devices. It's a global computer network providing a variety of information and communication facilities consisting of interconnected networks using standardized communication protocols. It is widely accepted that creation of the internet began with groundbreaking works by several scientists between the period of 1960s and 1970s. For Brown, for instance, proposed the telecommunication system with redundant links while working for Rand Corporation in 1960. In 1965, Donald Davis. So please, can you hear me?
Yes, we can hear you.
What?
We can hear you.
In
But
1960s.
we can't
Okay,
see
no
your
problem.
screen. Okay,
We
just
can
go
see your
ahead.
screen, sir.
Okay. Let me try. I'm sorry.
If you can't, just go ahead. We can hear you.
Okay, no problem.
Thank you.
In 1965, Donald Davis added the notion of data being broken down into small pieces and transmitted back and forth simultaneously, thus creating the foundation of the vital internet technology now known as packet switching. The United States Department of Defense initiative called ARPANET drew from this concept when connecting college networks in 1969. This poised in a computer science data network known as Cyclades in 1971, Robert Kahn and Bitten served to create the transmission earlier in 1974. The TCP/IP is generally considered as the foundation of the internet for today's internet. The major development that effectively cemented the modern internet and brought it to the general public was the World Wide Web, created by Tim Berners-Lee. The World Wide Web is a from it. It's a way of accessing information over the medium of the internet. From what that has been said earlier, it's evident that no single individual or organization can strictly lay claim to the intellectual property authorship of the internet. It's simply too large and multifaceted. If we view the internet from an intellectual property perspective, some persons can actually lay claim to certain aspects of the internet. For instance, Berners-Lee could, as the web is one of his inventions, but he decided to release it for free by releasing the source code for free. Kahn and Cerf, creators of TCP/IP, also were disinclined to hold their exclusive rights to their inventions. Like I mentioned earlier, the internet cannot be owned, but can be controlled. Network providers like AT and MTN in Nigeria, etc., effectively controlled the global network by passing out internet access to internet service providers who then deliver it to customers. None of them can actually claim patent right over the internet itself, but can patent any hardware they create to facilitate their operations, so far as they meet the patentability criteria, wherever the jurisdiction they are applying for patents in. Another dynamic area of internet-related IP rights involves patents for things. Some aspects of IoT technology, such as sensors and other hardware, are patentable and very much likely to bring lucrative benefits to their owners. In conclusion, the communication industry is a wide one, and the internet, which is just an aspect of it, is broad as well. As noted previously, no one can fully lay claim to the IP right over the internet, but certain persons and companies can lay claim to some aspect of it, or facilities and hardware they create or invent that make it more easily accessible. Thank you.
Thank you so much, Esther. That's a great presentation. Thank you so much. So move on to group 3 or group 4. Anyone that is ready can proceed.
Good evening, everybody.
Good evening. Yes, please go ahead. We can hear you.
Okay, I'm trying to share my screen. Please, can you
Yes,
all
we
see
can
my
see your
screen now?
screen.
See my screen.
Yes, we can see your screen.
Okay, and
Yes, we can.
My name is Nini Nabasiwili, and I am presenting on behalf of Group 3. Our topic is IP protection for innovators in the pharmaceutical and medical industry. IP, that's intellectual property, can be described as intangible creations of the mind, and they include literary works, artistic art, and even logos, trademarks, brand designs. Everything that is birthed from the mind is included in intellectual property. Intellectual property can be owned by anyone in any industry, and this also includes the medical industries and pharmaceutical industries. In the process of doing business, it is necessary that creatives and inventors gain protection for their intellectual property. Protection for intellectual property is embedded in the various IP rights and laws. The various IP rights and laws in Nigeria, we will look at that subsequently, that the ones that are necessary for the medical and pharmaceutical industry. The medical industry covers all companies and individuals in various fields of practice concerned with the care and well-being of human beings. This includes doctors, nurses, lab scientists, pharmacists, and other auxiliary medical roles. The pharmaceutical industry, the pharmaceutical industry is concerned with companies and individuals involved in research, production, and manufacturing, as well as distribution of drugs and health products. The pharmaceutical industry is part of the medical industry. That's why when I was introducing the medical industry, I also included pharmacists. The medical and pharmaceutical industries in Nigeria contribute to the well-being of the Nigerian populace through the production of drugs and health products and provision of healthcare services. Professionals in these industries also conduct researches that improve the healthcare of the Nigerian populace. The medical and pharmaceutical industries also creates job opportunities for Nigerian citizens. These industries, in the course of their business, contribute to the national economy. Relevance of IP to medical and pharmaceutical industries. Companies and individuals in the medical and pharmaceutical industries are involved in production of drugs, research, as well as administering of healthcare services. As part of their jobs, drugs, healthcare products, and other forms of intellectual property are created. While medical and pharmaceutical industries are vital parts of healthcare, there are also commercial industries seeking to gain profit. IP is an indispensable mechanism of translating knowledge into commercial assets. There's a high cost of research and production of drugs and health products. So the protection of IP rights goes a long way to create a secure environment for investments in innovations made by the medical and pharmaceutical industries. So IP rights that are available to companies and individuals in the medical and pharmaceutical industries include patents and industrial designs, trademarks, trade secrets, and copyright. Okay, we'll look at patents and industrial designs. Patents and industrial designs are rights in Nigeria and are governed by the Patent and Design Act of 2004. Patents are rights available to inventors who make, use, and enjoy benefits arising from products and inventions they produce. Such products may be new or they may be improvements on already existing inventions. Industrial designs, on the other hand, refer to the aesthetic parts of a product. They include the choice of color combination, the way of packaging, which is peculiar to a given product. It also involves all the elements of branding, which makes a product easily identifiable. Patents and industrial designs are only protected and enforceable when they have been registered. These rights expire over a period of time and can be renewed as provided by the Patent and Design Act 2004. Now, in the case of Pfizer versus Polyking Pharmaceutical Limited and another, the court held that the defendant had infringed on the rights of the plaintiff's patent. The plaintiff were Pfizer. Obviously, they are a pharmaceutical company that have business in manufacturing and distribution of drugs. So the plaintiff's patent, the court held that the defendant had infringed on the plaintiff's patent by producing a capsule that contained the same organic compound that the plaintiff had exclusive rights over. So this, based on this case and other cases, we can see that patents are not applicable to inventions, medical organic compounds of drugs, the invention of vaccines and all of that. So we'll now move on to trademarks. Like industrial designs, trademarks are signs and symbols that are representative of a brand. However, to distinguish trademarks from industrial designs, they are not applicable to only the product design. For example, we take Amatem soft gel. The way that Amatem soft gel's packaging is what we refer to as the industrial design. However, the brand of the company or individual that makes that drug, their logo, let's use their logo, for example, is their trademark. Anything that anything that makes a particular brand or industry stand out, or individual rather, stand out from the rest, anything that once you see it, you'll be like, oh, that's Pfizer, that's a trademark. Trademarks make it easy for patients and clients to recognize and acknowledge the brand of a medical or pharmaceutical brand. It increases the ability of consumers to easily identify the drug and even the healthcare provider of their choice. Trademark rights in Nigeria are protected and regulated by the Trademarks Act of 2004. Trademarks must be registered before they can be enforced and protected. This is the same thing as the patents and industrial designs. We move on to trade secrets. Trade secrets offer protection for information that makes a product of a company or individual differ from that of a competitor of the competition. Such information includes, but is not limited to, information about unique formulae, chemical compounds, special recipes, client and marketing information. I would like to include here that an information or a piece of information cannot be regarded as a trade secret if it is not something that is profitable to the marketing and the business of any industry. They are enforceable. They can be enforceable without registration, and there is no statutory regulation on trade secrets in Nigeria. However, parties can enforce their trade secrets, their rights to trade secrets as contractual obligations. Contractual obligations, contractual relationship between them and their employers, or between them and someone who has the privileged information of their trade secret. That's mainly on the no disclosure agreement or the confidentiality agreement. Okay, we have the case of Pacesetters Incorporated versus Navicon Companies. In 2011, this is not a Nigerian case, a Californian jury awarded damages to the plaintiff in a case involving trade secret theft by a former employee. He sought to capitalize on the stolen information with a competing medical device company. He sought to use the information he had gotten from the plaintiff to make business for the competing medical device company he now worked for. Yes, he just sought to use the stolen information there, and the plaintiffs were awarded damages for that. They were able to enforce their rights. That's what I mean. Copyright. These are rights of an author to own, publish, and even alienate ideas which have been expressed in any given form. Copyright is necessary in the medical and pharmaceutical industry, given the need to research and also communicate various scientific findings. This right is applicable for articles, blog posts, thesis, and other forms of scientific and non-scientific publications. I will use, for example, the Aproko doctor. He has a right. He is in the medical field. He is a medical doctor, but he has publications on Twitter, on TikTok, videos on YouTube that actually portray and give information. He has the right to copyright his videos, to copyright the information he sends out. So that is why copyright is also necessary, given the technological advancements and the different ways of the various ways of communicating now are becoming more let's say more information is being put on the internet. So there is still the need to copyright these findings, copyright these awareness blog posts, these publications, so that it also brings commercial gain to the doctor, to the pharmacist, to the pharmaceutical industry, to whoever is making use of them. Copyright helps to prevent plagiarism and also enables the authors, like I had already said, to take credit for and make money from their brainchild. Copyright lasts for the author's lifetime and 70 years after. Okay, in conclusion, IP rights may not apply exclusively to products of the medical and pharmaceutical industries. However, the products are protected under the general IP rights and IP laws in Nigeria. By this, I mean that all the rights we have seen can also be applicable to other industries. They may also be applicable to entrepreneurs, but they are not exclusively, it's not just for the pharmaceutical and medical industries. However, the products of the medical of companies and individuals in the medical industry, in the pharmaceutical industry, still enjoy full protection under the various IP rights that we have considered so far. And registration and maintenance of some IP rights cost money and time, but in the long run, they are profitable for unhindered and good business. Thank you.
Thank you very much, really, for that wonderful presentation. I really learned a lot. So thank you very much. So we'll move on to group 4. Is group 4 ready?
Yes, I'm here. I'm just trying to share my screen. I don't know whether you can see the screen.
Yes, you can see your screen.
Am I audible or do I have an echo from my side because I'm using my headsets?
We can hear you clearly.
Okay, my name is Sami Zero and I'll be presenting on behalf of Group 4. Our topic for the day was technology transfer, contracts, licensing, and assignments. So I'll start by introduction of what basically technology transfer is. And in a nutshell, basically technology transfer is the transfer of technology from research outputs to the market. So basically it's the dissemination of skills, know-how that has resulted from research firms and universities at this intellectual property and know-how, which is in the form of patents or trademarks or any IPR that has been discussed before, for example, which has been mentioned by other groups before, which include patents, copyright, industrial design, trademarks. Now, the transfer of this knowledge or know-how to the market is what we term as technology transfer. And majorly, technology will result from research institutions, universities, and business institutions, not only those in research and development. So in a nutshell, we can also say technology transfer is the movement of data, designs, inventions, materials such as software. We can also say technological know-how, trade secrets, as far as they move from the inventor to the market so that they can be commercialized. So in other ways, we can term technology transfer as the commercialization of intellectual property rights. So depending on how you want to categorize your definition or methods or types of intellectual property, we can categorize them as vertical technology transfer or vertical commercialization. This chain of transfer includes basic research to applied research to development, and from development to production. So for those people who are familiar with maybe product design, you can also see there, but you have to consider conceive the idea. Then you actualize the idea in terms of producing the product. You protect the technology of the product via any form of IPR, such as patents. And then you also transfer that patent to the market. So this is also termed as internal technology transfer. And this type of transfer is mostly between research associations, such as university, government institutions, among others. Then we also have the horizontal technology transfer or horizontal commercialization. And this is when the technology has already been put in place or is in use within an organization and is now further transferred to another place. So take for this example, a university has designed a product. It has protected the product via patents. It has also decided to use that product in its own university or through a startup or a spin-off within the university, or a startup outside the university, whereby now they decide to, apart from them using it, they also license others, or they also transfer the technology to other industries which are not part of the university. Now, this is what we did a term as horizontal technology transfer or horizontal commercialization. And this type of transfer takes place between private companies, small and large business organization. As I mentioned it for the example of the university, whereby the university has already or doesn't have enough capacity to use its spin-offs, then it can also decide to use other companies or big companies outside the university or the R&D company. So what are the methods of technology transfer? Or basically, what do we mean like by what are the different ways in which you can commercialize your IPR? For us here, we have just mentioned but a few, but depending on how you would want to categorize it, we have assignments. Assignments, in other words, we call this an outright sale. So whereby the IPR, for the sake of a patent, will change ownership. Basically here, you are selling the IP right to another person who is now able to commercialize it. For example, you have invented a pharmaceutical product, let's say a vaccine. Now, because for one reason or another, you are not able to commercialize that yourself, you sell it to another company, say Pfizer, Moderna, or any other pharmaceutical company that has the ability and has the resources to commercialize that product. Now, when it comes to assignment, you lose ownership. So for example, company A sells its trademark or patents to company B. In this case, company B has the right to sell and it acquires all exclusive rights, whereby company A loses all the exclusive rights. Then the other method of technology transfer is licenses. Licenses are whereby they can be categorized as exclusive license, whereby the licensor gives a licensee the right to commercialize. However, in this case, the licensor does not have the ability to use other licensees. What do I mean? In this case, the person who owns the technology, for example, a patent, can commercialize that patent, but for them to license to another person, the exclusive license model does not allow that one. So in short, a licensor can only license to one individual, as opposed to non-exclusive license. Non-exclusive license is whereby a technology is being transferred to a licensee or more than one licensee. Not on the exclusive license, there were only two people involved, the licensee and the licensor. In non-exclusive licenses, the licensor can actually license to more than one licensee, hence the term non-exclusive. Why do these ones become important when it comes to commercialization? Depends on your IP right, or depend on the contract that you sign with the person who you want to transfer the technology is. Every IPR is thereby to benefit the person who protects it, or the inventor, or the applicant, or the owner. So you should actually be able to exercise caution when entering into a negotiation about licenses, because depending on, you might enter into a contract whereby you are signing an exclusive license, and then in the contract you sign as an exclusive license, but now you want to license it to another person. That one is not able to happen. The other method of technology transfer is joint ventures. As the term joint, it means two people coming together to commercialize the IPR. Another example of a pharmaceutical product, assuming that you have invented a new cancer drug, for example. Now you do not have the ability to commercialize that product. In our discussions, you might have come across whereby you can use IPR as collateral. The way you would actually use a tangible property to enter into business negotiations, you can still use IPR, for example, your patent or your IPR portfolio, to enter into negotiations. For example, you have company A, which do not have the technology, but they have the money. You have the technology, but you don't have the money. So in joint ventures, you agree through contracts and different kind of contracts, you agree that, hey, see here, I will provide the technology, you provide the human resource or the resources to actualize this product, or I will provide the product, you commercialize it, and you also take it to the market, such that you agree on the mode of royalties or you agree on the mode of benefiting each other. That is joint ventures. Then when it comes to franchising, for example, you have a trademark. The best example I can give is McD, McDonald's, KFC, whereby you have a trademark, and it is one of the most preferred methods of transferring technology. The companies generally transfer technical know-how or skills involved under this type of agreement. Sometimes it doesn't have to be trademark. It can also be, for example, formulations. I tend to, or most of you will tend to agree with me that if you eat a McDonald's burger and you eat a King burger, they taste different. If you drink a Coke and you drink a Pepsi, it's just different. So when it comes to franchising, you authorize different franchise based on the agreement that they can meet those standards that have been set by the franchisor. Then there is also another form of technology transfer or commercialization, whereby original equipment manufacturer. This is basically subcontracting agreement where a foreign company transfers relevant portion of its technology and to a local manufacturer. I think we have seen this one a lot. Then there is also what we call buyback contracts. It is a form of agreement between stakeholders from developing countries and large foreign companies, where a foreign company supplies industrial equipment in exchange for profit derived from the sale of raw materials or such kind of produce. So why is technology transfer this important? Mind you, in order for any country, one must ask themselves, why do we protect our IPR? There's a major reason whereby we protect IPR or intellectual property rights to enhance research and development, to promote economic development, and to promote technological development. So we transfer these technologies to other places. For example, Pfizer or other companies, let's say in Europe, they are beginning to set farms in places such as South Africa, whereby they can manufacture their vaccines very easily. But for you to be able to manufacture in those sites, you have to transfer the technology from where it is coming from to those areas. Mind you, once you do that, you'll be able to foster research and development in that area. So transfer of technology allows countries to develop, to discover new technologies along the value chain to disclosure, and also evaluation and protection of these breakthroughs. As I already mentioned, it promotes technology and economic development. When you actually transfer technology to a country, it tends to create employment. The example I gave, you have transferred technology to South Africa, whereby you have set a plant there, or you have licensed your vaccine to be produced in India because there's cheap equipment and labor. Now, when you do that, you promote economic development, you create employment in that particular country. There's also financial returns. Basically, during assignment, you sell. The most basic, or the most recent example is where Jack Dorsey and the management board of Twitter decided to sell a whole company with all its portfolio. I'm not privy to that agreement, but I understand now, basically the owner of Twitter, which is a very good trademark, has been transferred to Elon Musk. So technology transfer can also be felt through national and regional economic ties via growth through innovation, new ventures, strong industry to boost employment, as I have mentioned, whereby you transfer your technology to China to manufacture your iPhones, you transfer your technology to India to manufacture your pharmaceutical products. So agreements and contract. There's basically a biggest difference when it comes to agreements and different kind of contracts. The assignment, sale, vending, or grant licenses by the owners of technology with respect to its proprietary rights. So we also have contracts and agreements in terms of an obligation to transfer confidential information such as trade secrets, the process of know-how, for example, for traditional knowledge. By the way, I haven't seen a lot of people talking about TK, traditional knowledge and expressions. So we have the application of the know-how, We have the engineering of know-how, such as reverse engineering and application of those patent information or contracts. We also have the manufacturing know-how, which is more or less the ones which is being disclosed in patent documents. And we have the design know-how, which is basically in form of any other IP rights. So as I also mentioned, there's a very big difference when it comes to contracts, licenses, and assignments. So technology transfer in a wide range is a concept as compared to licenses and agreements. So generally, assignments involve outright sale. Licenses, basically, there's a change of ownership, but you retain the ownership, whereby we have the exclusive and non-exclusive, as I explained. So in licenses, there's no change of ownership. But however, in assignment, there's a complete change of ownership. Now, we also went ahead to check about the challenges of technology transfer. Majority of these people, you can ask yourself is, why do we have so many research and technology universities around the world, but we have very few technology which is actually in the market? What you might actually realize is majority of these technology transfer, technology universities, they have a lot of professors who are mandated to do research and innovation, and they come with very valuable technologies, but they don't find the light to the market. They're not able to be commercialized in the market because they don't have the funds. Funds here plays a crucial role. For example, another example I can give you, there has been a lot of debate in the pharmaceutical industry that Africans or developing countries per se, they should be given free vaccines, or patents when it comes to patents regarding COVID vaccine, they should not be protected via industrial property rights. Then the question is, we as Africans, for example, if we are given that technology, are we able to commercialize? Are we able to produce? Probably the question is no, because we don't have the funds. Probably the question is no, because we don't have the expertise. Probably the question is no, because we don't realize that we don't have the IP knowledge. We lack awareness that this is the important thing, that even the creations that we have, we should actually trademark them. We should actually protect them. Finally, we have poor policies. All these IPR commercial transfers, they are dependent on IP policies. There's something what we call technology transfer offices. These offices are mandated to transfer technology, and they're the ones who are involved in IP management. Now, the policies that are involved in this IP management actually should be good enough to ensure that, or to provide incentives in the proper clauses to enhance technology transfer. The recommendations are: one, probably we should be sourcing for a lot of funds for research and development and IP commercialization. We should also restructure our technology transfer offices to ensure that they involve staffs such as those who are IP lawyers, staffs those are business liaison officers, etc. Then we should also actually ensure that we promote research institution or industry linkages when it comes to commercialization of industrial property, or what we call technology transfer. Again, you might have realized that for technology transfer to take place, there must be at least a national IP strategy. So where you don't have a national IP strategy, it is going to be hard for people in technology transfers to be guided in terms of transferring technology to the industry. Thank you.
Okay, thank you so much, Zero, for that wonderful presentation. You've done really well. I want to appreciate all the mentees that have presented for their various groups. Thank you so much. So we'll move on to, we'd like to hear from our mentors. I don't know if Mr. Folaren is around. I haven't seen his name, but I can see Mr. Max. Good evening, Mr. Max.
Yeah, evening. I hope you can hear me clearly. Apologies, I'm at the MBA branch meeting for Abuja, so I just had to find somewhere outside so I can come on.
Yes, sir.
But
We can hear you.
I've been listening. Yeah, I've been listening all the while and really enjoyed the presentation.
Okay. So, sir, you have the floor. Kindly comment on the presentation so far. We're looking at intellectual property for innovators today. So that is what all the groups have presented on. So.
Okay, yeah, thank you. So, like I said, I've listened keenly to the presentations, and I've really enjoyed the presentations. I particularly enjoyed, I believe that was group two, or yeah, I think that was group two's presentation, and I particularly am impressed with the angle the mentees have taken towards addressing the topic of the day, and I believe the topic is also one that is hugely important, because when it comes to innovators, I mean, there are many kinds of economic players, but innovators are a particularly very vulnerable economic player. And I'll just try to use examples, to compare them with other economic players, so we can see the unique vulnerabilities that innovators have and why IP is so important for innovators. So, for instance, I believe that was group two I heard talk about manufacturing, the role of IP in manufacturing. So, manufacturers, for instance, are a unique type of economic players. They produce, they produce let me say they produce goods particularly, and how they make their economic returns is that they hope that their cost of production is lower than the price for which they sell those goods. That way they make a margin on it. So to a large extent, their trade to a large extent is governed by by commodity issues, that price, competition in the market and other things. But if you compare manufacturers to innovators, then you see that for innovators necessarily don't directly make money from the sales directly, but more often than not, the innovator is the one who creates the unique features that makes a product to sell. So invariably, the innovator is higher up, or let me say lower in the food chain, because the manufacturer produces the goods, he sells to another economic player who would be maybe the wholesaler, who buys in large quantities, sells to the retailers, and the retailer sells to the ultimate consumer. So you can see that the person who gets the first bite at the cherry will be the retailer, the man who has maybe a supermarket or sells at a mall. He gets the money directly from the final consumer. So he gets the first bite at the cherry, and then of course he passes through the value chain backwards all the way. So to get to the manufacturer, typically the innovator sits somewhere after the manufacturer in the food chain. He creates a new way to produce the product, new features in the product. He thinks of innovative ways to make the product more marketable or more appealing to the consumer. But invariably, he's sometimes paid as a consultant by the manufacturer. He doesn't have direct relationship with the ultimate consumers. He's not the one picking the money directly from the consumer. So because of that, he stands in a precarious position. What he's selling more often than not is not tangible, it's not physical. So protecting it needs intellectual property. So it means that even though the retailer also needs intellectual property, for instance, trademarks and industrial designs in marketing his product effectively. But you find that for the innovator, his need for IP is higher, because typically the innovator's IP would be maybe in trade secrets, would maybe in patents. So it would also sometimes be in industrial designs, of course, could also be in copyright and in trademark. But increasingly, his own IP that matters to him is more increasingly trade secrets, patents. So, and you find that because of that, if the innovator is not careful to protect his IP, he would easily get passed over. So sometimes all he's getting is just some miserly amount as consultancy fees for helping consult on a new manufacturing process or in a new chemical formula that makes maybe pharmaceutical drugs more effective and all of that. But ultimately, if he does that alone, then he's not benefiting directly from his innovation. The best model to monetize for an innovator is to ensure that the innovator gets some form of ongoing royalties with when the product for which his innovation has been used is sold. That would of course be the ultimate and the height. So sorry, my comment is just broad, and I'm just trying to just come from a broader point and touch on what all the different speakers have said. So, and then particularly, I noticed a lot of the speakers focused in on the pharmaceutical industry. And pharmaceutical industry is actually one industry where IP for innovators is cardinal and key.
without IP protection, I keep telling people there are some industries that would not exist, or at least will not exist at the scale at which they exist and will not be as profitable as they are. One of those industries is the pharmaceutical industry. Without IP protection, nobody's going to bring out this money to become an innovator, to invest so much in research and development. Because if you do that, then your competitors will simply wait for you to do all the hard work, put in all the sweat, put in all the money in R&D, create a new chemical formula, more effective drug, and they simply take it up, incorporate it in their own drugs, and begin to sell. And you have no advantage, no competitive edge in the market, which a patent or trade secret would have given to you. So, pharmaceutical industry is one key area where innovators in that industry must be on the top of their game when it comes to IP. So, I also heard I believe, speak about research institutions. Now, that's another huge area where Africa is missing it completely. The innovators we have in our research institutions, professors in the universities and all, are not getting the most from their IP. And that is because, to a large extent, as innovators, they have not understood the importance of IP. So a lot of them, for instance, if you are in Nigeria, you are aware that the Association of Senior Staff of Universities are currently, that's ASU, are currently on strike. For them, what they are fixated on is the wages that government pays them to act as researchers and lecturers in the universities. But they forget that one of the greatest things they could get, actually, if they properly manage their IP rights, would be a lot of royalties and other incentives that they get from the commercialization of their research findings. So I spoke sometime last year at the IP Society of Nigeria conference, and what we're looking at that conference was industry university collaboration and how to monetize research products of research. So one of the things that our institutions have not understood is that when it comes to IP, universities should structure themselves in a way that at least a good chunk, I would say at least over 30 to 40% of their activity should be focused on the research part of things. And it should not just be, research for the purpose of teaching, but it should be research that is focused on industry. And that is why the universities have to now decide, look, we don't pick research interest just because of what we are trying to get across to the students. You will go to the industry and ask the industry, what do you need? Do you want your machines to work faster? Do you want it to be, to produce quicker? Do you want it to be more durable? What exactly do you want as industry? So it is the interest of industry that should govern what the research institutions actually spend their time and their money on. If they can do that, then to a large extent, our research institutions will now be weaned off government allocations or be weaned off just living off student tuition and other payments that they raise. They could begin to get a lot of money from monetizing their IP. I believe Group 3 mentioned licensing, for instance. They could license their IP. They could even do IP and assign them the IP to the industry. So you enter a collaboration where the industry finances the research product, and then all the product that comes out of it, once you register the patents or trade secrets or whatever, you hand it over directly to the industry. So that way, research institutions will be properly funded and will not have some of the challenges that we keep having in Africa. So I think with these few remarks, I'll pause at this point. I know that my co-mentor is also going to speak, and of course, my maximum respect to Mr. Folarin Aluko, as always, like I said, he's somebody you should listen to if you really want to make it in IP in Africa. I mean, he also mentored me, so he's coming as a grand mentor, because I'm his mentee as well. So if I'm a mentor here, then he's coming as a grand mentor. So please listen to him. And then, of course, I already see some interesting questions coming up. So I look forward to engaging with those questions when the time comes for Q&A. So thank you, and back to you, Grace.
Oh, thank you so much, sir. Thank you very much for this wonderful 10 minutes. It has been, and thank you so much for sparing your time, even though you're in an MBA meeting at the moment. Thank you very much. So we'll move on to our grand mentor, Mr. Folarin. I look forward to your presentation, sir. You're somebody I look up to in this profession. So I'm very privileged to anchor to this section. So I've learned a lot already, and I'm putting my ears down to learn a lot from you, sir. Over to you, sir.
Thank you very much. This is a setup for Grace. This is Max. Max is our grandmaster. But I should say a big well done to everyone. I listened to the presentations very keenly. You pardon me. I cannot talk for too long. I have some interesting. Thank you, Juliana. And I also cannot turn on my video, so I don't scare some people away. But I think I haven't listened to the conversation, but I think the theme of today's meeting is very topical. It's topical in the sense that, you know, Africa is considered to be the source of innovation in the world. And in particular, in the 21st century, Africa is a destination, you know, or a huge producer of innovation in the arts, and culture, and to some degree, to a much lesser degree, in science and tech. And I say to a much lesser degree because, unfortunately, we've not been able to fashion systems by which we can protect, recognize, and then commercialize innovation. And I don't mean just the laws now. I'm referring to like policies, government policies. For example, you know, if we had policies that promoted certain types of, that gave tax holidays to certain businesses, you know, apart from what we have under the National Investment and Promotion Council Act, but policies that incentivize, you know, work in certain industries like fintech industry or in medical research. And I heard somebody mention the need for an IP policy. I think that is a very, very important. It's a very important step that we need to take as a country, especially because in 2022, our greatest, well, you can argue that our greatest non-oil exports are really intellectual property. They're intellectual in nature. You know, from Nollywood, I read a quote from a minister in Zambia who said that Nigerians don't understand, or that we underestimate the value of Nollywood. So from Nollywood to UGC creators, that's user-generated content creators, to the music industry, you know, and all the other industries surrounding the arts, the performing arts, you find that there's a huge market for content there. And of course, you can see that it has attracted companies like Netflix, you know, YouTube, Facebook, and other streaming services. So I think it was very, highlighting the need for a national IP policy is very important. And that policy, the policy shouldn't just be a document that exists like some kind of academic thesis, but the policy should speak to how the federal government and the state governments, you know, should respond to certain specific industries. For example, if we're talking about geographical implications, I know Max has done a lot of work in that space. You know, how should states treat geographical indications or treat the system for registering and for protecting geographical implications? Olumoro, for example, you know, Ekong and so on. So the policy should speak to these particular, this specific fields of intellectual property and fields of creative endeavor. And I like the fact that we talked about the pharmaceutical industry, which, of course, in the conversation about patents and designs, or in the conversation about patents, the pharmaceutical industry really runs on research and development. And we have, at the last count, I think I counted, I tried to take an inventory of research institutes that deal with scientific development in Nigeria. And at the last count, under the Ministry of Agriculture alone, I think Nigeria has about 16 or 17 research institutes. We have a sugar research institute, we have a We have storage research, all manner of research institutes. But then the question now is there a connection between that research and some kind of productivity, or is there a connection between that research and innovation? If we have an institute that conducts research into product storage and things like that, why don't our farmers, or why haven't our farmers, embraced the products or the results of that research? So there's a huge gap that exists between the available research, and this research is funded by taxpayer money, by the way. So there's also the question of what then happens. How do we incentivize the private sector to go into, R&D? How do we incentivize private companies, and not just the Pfizers and the Smith-Kline Beechams of this world, but how do we incentivize the Max Ekong and Co, Max Ekong Pharmaceutical Limited, to engage in, to conduct and to carry out research into perhaps the properties in the agbo leaf. I remember when my daughter had cradle cap as a baby, there was this Sebamed, there was this soap that was recommended by the doctor. But then my mother brought some agbo leaves from Lagos, and we would boil the agbo leaves and apply to her head. And it dealt with the cradle cap. So there's a huge gap in that space. And I think, talking about technology transfer and knowledge acquisition, there's also a need to have more conversations centered around how do we translate this innovation into, or this research into innovation, and then how do we now translate that innovation into a commercial product that Nigeria can then, or that this company, it doesn't have to be the country, but that the company can market to the world. And I would say once again, fantastic work. I really appreciate the extent of the research and aptitude that went into the presentations. I would say well done. And I think beyond just, yes, I know people are watching live on YouTube and on Facebook as well, but it will be very good. I think this presentation should make their way to the business community, because, I was talking to somebody this morning and the person said, oh, I want to start selling hair. And I asked why hair? And the person said, oh, hair is a fast moving product. And I said, well, that's true. But then so is crude oil. And you could decide to go to the Niger Delta creeks to sell crude oil. Why aren't we all selling crude oil in the creeks? It's because these products are very easy. You already have a steady market. Private businesses need incentives to engage in R&D and to engage, to spend their resources developing, ideas that can be marketed to the world. And there's a huge, I think the role that the federal government and the state governments play in this regard is to create an enabling environment, and a policy that speaks to how that can work, in a cohesive way, will go a very long way to making this happen. So I would say fantastic work, both Group 1, Group 2, Group 3, and Group 4. I enjoyed the conversation on technology transfer, and the NOTAP, the National Office for Technology Acquisition and Promotion, set up technology transfer centers across the country. But there's this question of how effective have those centers been, in facilitating the transfer, quote unquote, of technology from, one part of the world to our Nigerian brothers and sisters in the tech industry. I know as far as the review of agreements goes, NOTAP has done a lot of work in balancing, ensuring that the agreements don't unduly impair the ability of Nigerians to learn. But I don't think that, I think we will benefit a lot if we have a situation where the market can determine, if market forces are conducive enough, you wouldn't have to go asking foreign individuals to bring the technology to Nigeria. They would invest in that technology here in Nigeria. And I think I'll close up on this technology transfer conversation with a story. I had a meeting with a client 2 weeks ago, and he showed me this building technology. He's marketing it for the Chinese, for a Chinese company. And fantastic stuff. They built a 5-story building in 24 hours, fully fitted with a lift and with all the fittings and fixtures of a residential apartment. A 5-story building in 24 hours, fantastic stuff. But guess what? They don't, every single thing, and it uses steel and some prefabricated materials. And they say that it is, the structure is earthquake resistant, But guess what? If the only way that, if one wants to engage them, you will have to pay them, and then they will fabricate all the parts. They will design and fabricate all the parts in China, and then import the parts to your country, and then set up the building. And what you have there is a situation where there's a deliberate attempt to keep that knowledge. Of course, you could say it's a trade secret. I don't know whether the patent has been registered in relation to that information, but there's a deliberate attempt to keep that knowledge hidden. And my question is, if Africa is so, if Nigeria specifically, if we're so free with, the information that we give, allow the world to if we're so free with the information we allow the world to harness from, or to harvest from here, we should start thinking about how we can take that information, use that information, and then sell it to the world as well. So thank you very much for having me. I'll just sit back and wait to learn some more, and also take some of the questions. Thank you, Grace. Thank you, Juliana, and nice one, Max.
Thank you very much, sir. Thank you so much for that impactful section. So we'll just go straight up to the questions. So I'll just post the questions in the comment section while reading them. So just give me a minute, everyone. Okay, so sir, kindly take question 1. So I'll just read out question 1. It says, how can we know that a patent has been infringed on, or what are the determinants of patent infringement?
Okay, yeah, that's for me, right?
Yes, sir. Mr. Max, that's for you.
Okay, yeah, that's a very interesting question, and a really and a really good question. But the answer to that is to ask yourself essentially why a person would, in the first place, want to use a patent in a product. So the idea of a patent in a product is that you want to, create a competitive advantage for yourself by using something new and innovative that makes your product more attractive, maybe makes the production process quicker and faster or better, but essentially you are trying to communicate to the consumer that, look, I have a superior product, or you should patronize me because my product has embedded in it some new technology, some new innovative, way it runs. So the idea behind it is simply this: if a person steals your patent, the person is not going to hide it under his bed. He's going to want to use that patent to market his products. He's going to want to use the innovative features that you have patented as a leverage to enhance, to increase its market size. So typically, just by putting your just by putting your ears in the market, you will know easily if someone is stealing or is infringing on your patent. So I mean, that's the marketing side of it, or the, let me say, the investigating side of it. But now getting more close to it now, of course, you are going to need expertise, expert help when it comes to actually knowing if the person has truly infringed on your product. So of course, there are basic tools used. First of all, foremost, what to call mystery shopper. So mystery shopper means that you go ahead and buy that product so that you can actually see the product for yourself and be sure that, okay, this product contains part of my invention, which are protected using a patent. Of course, sometimes your patent might not be a product, so that might not work. It might be a production process. So it could be the way you produce your product. So another way, of course, to do that is to simply reach out to the person who you suspect is infringing and say, look, I want you to produce this for me, but I'm not sure. Are you able to produce at this rate? And if you're able to produce at this rate, how come you're able to produce at this rate? And of course, it won't be long for the person shoots off his mouth and says, look, we have a new innovative way of producing that would guarantee that. So essentially, putting your ears to the market is the quickest way to know if your patent has been infringed. Then, of course, there are the technical sides of infringement, which would be infringement involves a person producing, using your patent, importing products that incorporate your invention that you have protected by patent. So there's a practical case study in Nigeria where somebody had registered a patent for collapsible ballot boxes. And the Nigerian Electoral Commission, INEC, went ahead to put out a bid. And some foreigner, I think from Indonesia or somewhere in Asia, was able to import those same collapsible ballot boxes. And the guy went to court, and the court found for him that indeed, by importing the ballot boxes into Nigeria that incorporated that invention that had been protected by patent, that was an act of infringement. So infringement could actually be through any of those barometers. So like I said, the basis is that you must put your ears to the market. That's why when you advise your clients to develop an IP strategy, beyond registering their patent, they must have a system where they are marketers or some special unit is always monitoring the market to know what is happening. Of course, sometimes how you know is that your sales figures begin to fall. Then you know that, okay, something is wrong somewhere. Why are we suddenly no longer selling in the north, or why are products no longer selling as they were earlier on in maybe the east? Then you send an investigator to help you check out what is happening there. You won't be long before you find out that somebody is scooping out your market. Thank you. Back to you, Chris.
Okay, thank you very much, sir. So, Mr. Folare, this next question is for you, sir. So it says, how can I mitigate the negative effect of patent in regards to competition and technology diffusion? And how can I combat the problem of identifying the location of infringers in situations whereby the internet domain name is different from the residential address? So there are two questions here. Hello, sir.
Yes, I'm here. So you can see the question, Carrie Belair.
Yes, you can say that again. So over to you, sir.
Can I mitigate the negative effect of patents in regards to competition and technology diffusion? So I'm guessing what this person is asking there's a presumption first that patents negatively affect, or well, I'm guessing the person is referring to the restrictive application of a patent right, or the monopoly created by a patent right, and how that would affect somebody who is competing with the patentee in that space. Well, I guess the first thing one should note, and I think it was mentioned in the course of the presentation, is that patents are the creations of the states. So they operate on a territorial basis or within a territorial jurisdiction of registration. Although the world is actually moving towards, a more globalized system of enforcement, and that's why you find more countries are signing up to the Patent Cooperation Treaty. Nigeria, of course, is a signatory to the treaty. But even at that, even signing up to the treaty is not enough for patent for a patent to be enforceable within a jurisdiction. So I would say that one has to register in that jurisdiction. So I would say that rather than look at the negative quote unquote effects of patents, it's much easier to look at the positive effects of patents. Patents are a source of information, and they provide a very huge source of know-how in terms of how things work to a large degree. You can, reading a patent application or looking at the specifications or the description or even the diagrams along the patent application, you can help one leapfrog and cross so many hurdles that would have cost the inventor, innovator a lot in terms of that R&D. So I would say, rather than asking the question, how do we mitigate the negative effects? We should look at, okay, how do we leverage on the positive effects? Because the negative effects that like I said, have to do with the ability of the patentee to restrict others from, infringing on the patent. And if we agree, if we are in agreement that patents help drive innovation, then we would also agree that the owner of the patent should be entitled to, that protection for whatever period. I think it's 20 years in Nigeria. And so I would say for negative effect, how do you avoid the negative effect or mitigate it? The best bet is keep doing your research privately, or and don't infringe. That's the only way to mitigate. Don't infringe on the patent. Unfortunately in Nigeria, if you look at Section 4 of the Patents and Designs Act, there's a caveat, in the act, and the caveat provides that patents are granted at the risk of the patentee without any guarantee as to validity. And the reason why that provision exists in our patent act is because patents in Nigeria are not subjected to substantive examination, as to the substantive requirements for patentability, novelty, inventive step, industrial application, and so on. The Patents Act, I think Section 4 sub 1 provides that once the formal requirements, still in Section 4, once the formal requirements for registration have been met with, the registrar does not have any discretion. The registrar has to grant a patent. So because it's examination free, there's that sense that your patent can only be validated upon a challenge in court. And that's what happened in the Beddings against the Independent National Electoral Commission case that Max made reference to. But taking that step further, I am also aware that South Africa also has a similar situation. So the South African, I think it's the patents law does not also require a substantive examination, but a patent certificate is still treated as prima facie evidence of validity of that patent. So you could have you have two systems that are similar, but with a different impact. So in Nigeria, a patent certificate technically is only valid upon a challenge, by an individual or by the patent holder, because the act actually subtracts from, it subtracts from the value of that patent certificate. You can distinguish this with a trademark certificate that is prima facie evidence of compliance and of the validity of the contents of that trademark, or what is on the trademark certificate. So it kind of shifts the burden of proof to another party in the event of a dispute. So if we're talking about how do you mitigate the negative effects, I would say don't infringe. That's number one. But flipping that question around now as to how can we benefit from the positive impacts of the patent system, especially with regards to competition and diffusion. I would say research. There are many resources online. Google Patents, fantastic resource. WIPO also provides a lot of fantastic resources as well. It's important that, of course, in doing this, and technology diffusion presumes that somebody files a patent in Asia, let's say in China, for example, and then someone in Nigeria is trying to who is also working on something similar wants to take advantage of that information, I would say the first thing is don't infringe on the patent. And you can't do anything about the diffusion of technology and the globalization of commerce and competition, and even in Africa, with the once the AFCFTA comes on board, the entire continent of Africa will become almost a single economic zone. And so that when talking about the diffusion of technology or diffusion of commerce and competition, things are going to get a lot more interesting very soon. And so I'll say, rather than the way to avoid the negative effect of patents, just don't infringe, or get a patent lawyer and look for some of the loopholes. But I'll say don't infringe. And then the question of how do you combat the problem of identifying the location of infringers? So presumably, depending on the nature of the patent, and patents speak to a very wide range of intellectual property subject matter. So it could be a process, it could be a product, it could be an improvement. So it's a very wide range. And in Nigeria, very recently, the Patents Registry has been very happy to approve the registration of computer-generated invention, software patents. So I think a software patent would apply in this situation more specifically. Especially in the situation where the infringement is such that it can take place online. I don't know how one, of course, there are ways one can infringe on a product or a process patent online, but if I'm guessing this question speaks to, or this sub-question talks about how do you identify or locate a potential infringer? Finding infringement or enforcing infringement is a multidisciplinary function. In Nigeria, the Nigerian police is a huge part of that function. I understand that customs is also a very huge part. So using the internet to trace a potential infringer or an alleged infringer, is the internet is just one tool. But who are the parties? What agencies should be involved? Very recently, I understand that even the Economic and Financial Crimes Commission have gotten, now participate or are now being engaged in prosecuting, trademark infringement matters or investigating trademark infringement matters. So I would say that in prosecuting infringement cases, the domain name can provide resources for identifying where the infringer is. Presumably, if the domain is hosted with a registrar that has the details of whoever registered the website. But then we all know that when it comes to doing stuff online, especially on the internet, there are so many ways one can hide one's identity. There are virtual private networks now. You have, of course, the Tor network, Tor browser, and so many other ways that one can hide one's identity. In fact, these days, a lot of individuals also use third parties to build and develop their websites. So you find that the name of the individuals actually running the site may not even be contained, in the WHOIS if you look at the registrar's information. So I would say, in terms of locating infringers, one has to look at it from a multidisciplinary point of view. In the US, the Federal Bureau of Investigation plays a very huge role in investigating and prosecuting trademark infringement. And they do that in concert with the ISPs, the internet service providers, who are very happy to provide, it's not just about the domain name address now, but where that ISP, you can it's easy to locate, to find out which service provider provides the service to that person. And then, from that service provider can now triangulate the location of that customer and provide information as to where that customer is located. But how that applies in Nigeria is a totally different conversation. So I hope I've been able to answer that both questions successfully, both the mother and daughter question.
Yes, sir, you have. And thank you so much. So I think Mr. Max can answer the third question. It's equally a very broad area too, but I hope he can just streamline it. Mr. Max, please, the next question is for you. I don't know if he's still with us. How do medical and pharmaceutical companies enforce their IP rights? Wow. Okay.
Okay, yeah, can you hear me now?
Yes, yes, we can hear you.
Okay, yeah, so yeah, that's a question I believe we have touched on to an extent
Yes.
for enforcement of IP rights in medical and pharmaceutical industries. Like we said, a larger chunk of, different industries have where their IP rights kind of congregate. So, if you're talking of entertainment industry and the recreation sports industry, a lot of it will be focused more in trademark, in copyright. But when it comes to medical and pharmaceutical industry, the greater concentration would be, with patents, would also be in trade secrets, to an extent also would be in design. And then of course, trademark is a very significant part of the medical and pharmaceutical industry. And I'll try to explain how that works, because when it comes to the medical and pharmaceutical industry, what you essentially want is to build and enjoy as much of a monopoly as you possibly can get. So how to do that is to structure your IP plan in a way that you start with the time-limited IP rights, and then you build it up. So practical example would be you get a new chemical formula for a drug that cures, let's just use the common ones we know in Africa, malaria, for instance. And you get a patent on that drug. Now that patent is going to last for 20 years. After 20 years, any other person in the market can use that same chemical formula in their own drug. So one of the smart ways to deploy your IP rights to ensure you get the longest possible protection is to remember that with trademarks, you actually have a protection that can last perpetually, provided you continue renewing it. So for instance, there's a trademark, I think one of the oldest registered trademarks was registered in the UK in 1874, and that trademark is still valid till today because they have continued to renew it, successively through the years. So what you do in that case is that when you develop a new drug, normally drugs have what they call a generic name. So the generic name is a name that is typically tied to the chemical formula of that drug. So for instance, with painkillers now, that would be paracetamol. That's a generic name that tries to describe to an extent the active chemical ingredients that make up that drug. But now there's a brand name. So the brand name, for instance, would be Panadol, which would be the brand name you give to your own drug. So what you want to do is that in the 20 years that you have your patent that gives you that monopoly over paracetamol as an active chemical ingredient, you ensure that you create a linkage between paracetamol and your brand name Panadol, so that everybody comes to recognize when they think of paracetamol, they are thinking of Panadol. So that in 20 years' time, when other people can create their own painkiller based on the same active ingredient of paracetamol, the market has already recognized your Panadol as the trusted brand of paracetamol. So by that you have linked your patent right to your trademark right, and then you can perpetually continue that monopoly using your trademark right even when others come into the market. So that would be one clever way to design your IP structure in the medical and pharmaceutical industry to perpetuate your monopoly, as it were, and ensure that you can get good returns on investment. Of course, there are also some illegitimate ways. So one of the questions talked about some of the abuses. So there are some abuses in the pharmaceutical industry. One of them is what we call evergreening. So evergreening is a practice where you develop a drug. Now, we know that drugs usually are not perfect. They would have side effects. So perhaps I develop a drug, say maybe for malaria, say chloroquine.
Now, one of the side effects of that drug is that it gives you insomnia. You are not able to sleep well when you take it, and then you itch a lot on your body. So evergreening is a practice where I recognize that my drug has limitations, but I deliberately leave some of those limitations. And then I wait until the 20 years when my patent on my original chloroquine is about to expire. And then I suddenly release a new and improved chloroquine based on a new chemical formula that eliminates maybe the side effect of insomnia. And then I get a new patent grant from that 20 years. So it means that while other people can come into the market and use my old chemical formula, they would be competing against me who has an improved version. So by the time my improved version is expiring in the 40th year, I suddenly release a new and improved version that now eliminates both insomnia and the itching. And then I get another monopoly for another, that stretches my monopoly to 60 years. So you can see that it's not exactly a wrong thing to do, because patent, like we said, is on innovations or new and improved versions. But you can see that I'm now using the new and improved in an unethical way to extend my monopoly. So that could also be some of the negative sides of patent, where the law now has to come in and modulate and bring some sort of balance to avoid that kind of abusive practice. So these are the dangers, but the law is always trying to keep that balance. And of course, sometimes the ethics of the pharmaceutical and medical industry also try to say, look, if you have a better product, release it immediately. You should not keep it back the moment the clinical trials are done. Don't keep it back just for the purpose of perpetuating your monopoly. Thank you, Grace. Back to you.
Oh, okay. Thank you very much, sir. So before you go, finally, Mr. Max, let me just kindly take the next question so that our grand mentor can take the remaining two.
Okay. Hi, Grace. Can you hear me?
Yes, sir. Yes, I can hear you. Okay, please give me a minute, let me get the questions in. Or does one have the questions? Can you post it on the chat box so that I wasn't out and I can't find the questions anymore?
Okay. The fourth question, are we on the third or fourth?
The fourth.
The fourth question is, are the names of pharmaceutical companies also protected under IP, like trade names?
Yes, so Mr. Max, kindly, you can just answer that one before we let you go.
Okay, yeah. So that's also a good question, and that question ties into what I just mentioned before. Definitely, as a pharmaceutical company, you should protect your company name, because that's one of the unique identifiers that you are using to market your product. Because there are many other pharmaceutical companies marketing same or very closely similar products. So if you don't, your name should also be used as one of your brand items as well. And then of course there's what we call a house mark or a family mark. A family mark is typically the name of the company itself, and then there are sub brands under it. So for instance, we all know, let me say, GlaxoSmithKline. We know Pfizer for instance. So Pfizer is protected as a trademark, and then beyond that, Pfizer has other brands that they put in the market. So they also protect this one individually. So in developing a brand protection structure for a pharmaceutical company, you see the structure that way. You protect the overall name of the name of the company and the overall brands you are using to market your product, and then you build that. Because sometimes what pharmaceutical companies do is that rather than give every drug a new name, they simply use a generic name plus their brand name. Just add your company name to the generic name, so you can say Ekong paracetamol. That would also be an effective brand strategy. But of course, in doing that, no matter when you are registering a trademark, you can do what they call a disclaimer. So you disclaim exclusivity to a part of the name. So you make it clear that the brand name, the generic name, which is the chemical formula, you cannot trademark that, because that's not allowed. So in filing your application, Ekong paracetamol, you make it clear that I disclaim any exclusive rights to the word paracetamol. That's a generic name that anybody in the industry can use. But however, I claim exclusive rights to mark Ekong. But when the two are put together, they become distinctive enough to give you that protection where you are using your company name and the generic name, and you still have an effective product. So certainly, if a company should protect its brand name and its company name as much as possible, register it as a trademark. And then of course the issue of trade names is quite different, but a trade name essentially is just a name in which a business is carried on, and it could usually of course the company name. Sometimes it could also become a brand item. So typically, if it is distinctive, so for instance, if I'm selling drugs and my company name is a medical medical magic limited, for instance. Now, of course, you know that to register that as a trademark will be difficult because medical is already a generic name that anybody in the industry should use. So I shouldn't be able to register that. So if your company name is generic, then you might not be able to protect it as a trademark because at that point, you can't, you won't be allowed to monopolize that generic word that everybody can use in the industry. Yeah, thank you.
Okay, thank you very much, sir. Staff, over to you. This next question is for you. He says, it is clear that patent is the most crucial intellectual property available for pharmaceutical companies. But where there is an innovation on a patent, is there still a breach?
Could you please read that for me
Hello,
again?
sir.
Hi, Grace. Could you please read that for me?
Yes, it is clear that patent is the most crucial intellectual property available for pharmaceutical companies. The question is, but where there is an innovation on a patent, is there still a breach? Wow.
Okay, fantastic question, and thank you. It's been a learning, and well, it's not an earning meeting, but it's been a learning and it's been a learning experience for me. Of course, it's a very good networking too. Hello, are we all there? Hello?
Yes.
Oh, fantastic. Okay, I thought I was looking at the Nana's picture and I thought I lost you. I have to put on that the white switches at the back. Yes. So I think this question speaks to the concept of improvement patents, and I think that there's a general philosophy in intellectual property law that intellectual property law protects the expression of the idea, not the idea in itself. And so what this essentially means is that what one can extrapolate this to mean is that in certain situations, the improvements on certain ideas should enjoy intellectual property protection. So with copyright, for example, we find that in section 4 of the Copyright Act, section 1, I think subsection 3 of the Copyright Act. Section 1, sub 3, I think. Section 1 of the Copyright Act provides that copyright in a work shall not be denied on the basis that just because that work infringes on the copyright in another work. And specifically speaking to this particular example, I would say that speaking to this particular example, the law does provide for and does recognize patents or intellectual property, improvements on existing, patented works, provided that, and I think in Nigeria you find that I think that's section 1 sub 2, that for improvement patent they must still meet the requirements of the inventive step novelty, and I think not obviousness. So it must not be obvious, and all the other requirements. So it must be capable of industrial application, must be the novelty requirement, and then the inventive step. So the law does provide for and does recognize innovation, on existing inventions, provided that they meet.
Sorry, please, can we hear Mr. Folarin?
No, we can't. I was just about to mention that I think he...
Okay, I think he might be having network issues.
Yes.
So I'm thinking that because of time, we might be rounding up. But just before we do that, I think Zero wanted to say something, so we can just give you 2 to 3 minutes to say what you have to say, and then we'll round up for today quickly, since Mr. Folarin is having network issues. Hi, Zero, are you still here?
Oh, yes, I'm still here.
Okay,
thank
so
you for that.
Give your comment in about 2 to 3 minutes.
Oh, the only thing I wanted was just to comment on what Max had said to do with question 1. And most probably the only thing I wanted to highlight, I think he mentioned it in his subsequent comments about, you see, when it comes to infringement of a patent, the whole responsibility lies within the patent owner. So when it comes to enforcement, I understand different jurisdictions have different ways of enforcement. But for example, in our country, we have an enforcement agent whereby while the enforcement agent keeps vigilance on those products that are infringing or they come into the country, but within the country, you as an applicant, or you as a patent holder, you have the sole right to ensure that you monitor the kind of patent in the market. You can do that by either engaging patent agent or patent lawyers to be able to be tracking every product that they see in the market. The other problem, though, as he mentioned it, when it comes to devices, patents for devices, which you can easily do reverse engineering, when it comes to formulation, you need to have what he termed as an expert who can be able to construe and be sure that whatever has been claimed in the patent is actually what has been manufactured. Maybe someone is actually infringing on, you think they are infringing, but literally you can't tell unless you have an expert in that. That's the only thing that I wanted to add on what he has said.
Thank you very much, Zero, for the addition. So I don't know if Mr. Folarin is back. So while we wait for that, I want to say a very big thank you to all our mentors, to Mr. Max. Mr. Max has been a solid rock behind us for a very long time, right from the first quarter. Thank you so much, Mr. Max. So while I'm doing the appreciation, please put your videos on. It's picture time. Please put your videos on and take your pictures. The reason for these pictures is for us to post on LinkedIn, post on social media, tag our mentors and appreciate them for what they are doing. It's picture time, game faces on, put your favorite side of the picture. So if it's your left side, stay on your left side. If it's your right side, stay on your right side, because this is picture time. Yes, I can see Willie smiling, oh shit. So thank you very much, everyone. I want to thank Mr. Max. Mr. Max is such an amazing support to us, and I want to say thank you so much. Thank you so much, sir. Thank you so much. And also to Mr. Folarin, the Grandmaster, thank you so much also for your time and everything. And for Grace, you are a superwoman. Thank you so much for moderating today. I can see Fola Kumi.
Thank you. Thank you, Ma.
Thank you so much. Please put your videos on, take your pictures, post about it, and make sure you appreciate your mentors, because what they are doing is a sacrifice. A lot of them have a lot of things they are doing, but they are here to make sure that they hold our hands and they guide us. So appreciation also to the mentees, all of you who are cooperating with one another to make sure that you write your work, put it together, present and all that. Thank you. So I've seen a lot of yes. Thank you, Jamil. Thank you, Esther. Thank you, James. Thank you, Dahisilu. Thank you, Sumibola, Chika, Mosopefu, Lua, Polami Grace, Mr. Zero, all of you. Thank you so much. I love you all. Please network with your friends, network with your mentees, because these are people that you might have as best friends for life. Some of you might marry each other, you never know. So thank you all, everyone. And so I'm not sure if Mr. Folarin is here, but I want to just say a very big thank you in absentia. Thank you, Mr. Max. Thank you, Mr. Folarin. Thank you, Grace. Thank you to all the mentees. Write on LinkedIn, post, tag your mentors, and have an amazing weekend, everyone. Bye. Love you all.
You too, Ma.